Hello friends, Namaskar. Today we will discuss about Section 17A of Prevention of Corruption Act. Basically, first of all, we have to note down the general idea about the said section. It says and mandate the prior approval from the authority competent before an investigation or inquiry against a public servant. The key point is that the action must be concerned with their official duty or function. The provision was introduced in the year of 2018 and basically it aimed to protect the honest public servant from unwarranted investigation or inquiry. Now we are coming on the provision. It says inquiry or investigation of offences concerned with the recommendations made or decision taken by public servant in discharge of official function or duties. Now please note down the said protocol is inserted by the Act number 16 of 18 which is in motion since 26th of July 2018. The Act number 16/18 is also called the Prevention of Corruption Amendment Act 2018. The provision says no police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by the public servant under the Prevention of Corruption Act where the alleged offence is concerned with recommendations made or decision taken by such public servant in discharge of his official function or duties without the prior approval. So we could say that the prior approval is sine qua non. So the said protocol recommend that no police officer can conduct an inquiry or investigation into offences allegedly committed by a public servant in discharge of their official function without the prior approval of the authority competent. So if the proceedings are conducted without the prior approval, in that scenario, proceeding would be nothing but abuse of process. Now the primary question arises, who will be the authority competent? And we are having three categories, A, B and C. In case the person is concerned with the affair of union, in that scenario, the central government would be the authority competent. In case the person is concerned with the affair of state, the authority competent would be state government. And in any other case, the authority competent will be the authority who is competent to remove the public servant from his office at the time when the offense was alleged to have been committed. And there is a proviso that says no such approval is required for cases involving the arrest of a person on spot on the charge of accepting or attempt to accept any undue advantage for himself or for any other person. So we could say that if the public servant is not caught red-handed, and apart from that he is charged with offense concerning with recommendation made or decision taken by such public servant in discharge of his official duty or function, in that scenario, the prior approval from the authority is sine qua non before initiating the inquiry or investigation. It may be the concerned government or the authority competent to remove such public servant from his office. Apart from that, there is another proviso that says, provided further that the concerned authority shall convey its decision under this section within the period of 3 months. So basically, if the file is put up for the approval, the decision is to be given, but the time period is 3 months and the period could be extended by 1 month. For this, the reasons are required to be recorded in writing. But the key point is that the reasons are required to be supported by consistent and corroborative evidences. If not, in that scenario, order would be abuse of process. To understand Section 17A of PC Act, we will take an example. The example is the recent judgment pronounced by Honorable Rajasthan High Court. Judgment title is Rani Dhan versus State of Rajasthan. Judgment date is 8th of October 2024. In that case, the public servant were charged to demand the alleged bribe. They were not caught red-handed, and in the meanwhile, FIR has been registered. The FIR has been challenged on ground that before doing the inquiry or investigation, the prior approval is sine qua non. Ultimately, Honorable High Court had quashed the entire proceeding on ground that there is non-compliance of Section 17A of PC Act. The logic is that the alleged act is having nexus with the official power. So in that scenario, the prior approval is sine qua non from the authority competent. If it is not accorded in that scenario, proceeding would be abuse of process. And apart from that, we are having judgment of Kailash Agarwal versus State of Rajasthan. In that case, the proceedings were quashed on ground that prior approval had not been taken. So whenever we are having cases wherein the accused is not caught red-handed, and apart from that, the concerned accused is inter alia committed the offence consent with the recommendation or decision taken by him in the capacity of official function or duty in that scenario while doing the prosecution, the prior approval is sine qua non. So I think that I inter alia enlighten all of you on the subject. If you are having any query, please feel free to put the same in the comment box. I will try my best to answer the query. See you in the next video. Till then, Jai Hind, Jai Bharat.